I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we're going to be discussing the latest developments in privacy in California. In particular, how are potential regulations going to look for key areas relating to AI and automated decision-making under California's important privacy law. As listeners of this show may know, we have seen significant activity relating to the potential regulation of AI and automated decision-making, in particular coming out of Europe, but also much conversation coming out of the state of California. Similar to where we've seen privacy develop over the years. So the GDPR was a landmark piece of legislation that established a framework for global data protection. And many aspects of that law has now made its way into the United States in their state laws that have embraced some of the same principles that are at the core of the GDPR. And now we're starting to see the same thing with respect to AI and automated decision-making. And so that's going to be today's conversation. And for that, I'm pleased to be joined by my colleague, Aaron Lariviere, to discuss the latest regulations that have been proposed for discussion, I guess, is the way to describe that in the state of California. Aaron, welcome to the podcast.
Hi, Scott. Thanks for having me. And happy to jump in and talk about everything that's going on in California. As you know, there's a lot.
That is for sure. It almost seems like we wake up every day and there's a new thing that's happening. I think in future episodes, we'll talk about new legislation that's coming up and affecting specific areas of data protection. But for today, I really want us to have a chance to talk about what the regulations could look like that are coming out under the CCPA and the CPRA and how those are looking to take shape. So maybe just set the stage for us. What is the CCPA? How has that developed over the course of the past couple of years? And what current regulations have the California regulators produced?
Yeah, just a table set. The CCPA is the California Consumer Privacy Act. It took effect in 2020. And that was the first comprehensive consumer privacy law that we had in the US. This was a California innovation. They took the GDPR template and kind of ran with it. So the CCPA introduced some new concepts such as sales and opt-outs for sales, and it kind of redefined the way we think of some of these terms. That law came into effect in 2020, and regulations followed. The California AG was initially responsible for drafting those regulations, and they added a whole other layer of complexity to this law. Fast forward a couple of years, and there was a ballot initiative called the California Privacy Rights Act, which essentially modified the existing CCPA and made it more robust and added a whole other set of new requirements around things like a new term called sharing, which expanded on the concept of sales. And these were all complex new ideas under US privacy law. Part of the changes that came in with the California Privacy Rights Act, which I'll call the CPRA, was that it introduced several new issues for regulations to be drafted on. In connection with the CPRA, the law established a new regulatory body, the California Privacy Protection Agency, the CPPA. There's a lot of acronyms, so apologies if it gets confusing. We have the CCPA, the CPPA, the CPRA. It's terrible. I'll try to be clear on those. But the new agency essentially is charged with preparing regulations on a handful of specific topics. Among those topics were the definitions of sharing and all these new opt-outs. We've already received those regulations. Those went into effect earlier this year in March. Since then, there has been some activity around some of the other topics that they hadn't addressed yet. And those include privacy risk assessment, which is going to be required for specific types of processing activities. Businesses that are subject to the CCPA, if they engage in certain activities, will need to conduct a privacy assessment. I think that's going to be the main topic of our conversation today. At the same time, they're also working on regulations for cybersecurity audits, which is going to be another requirement for businesses that meet certain specific thresholds. And Scott, I think you're going to be talking about that in a future episode. And then there's actually a third set of regulations that we know is in the works and we haven't seen a draft of yet, but it's specifically focused on automated decision-making technology. And that, I believe, is going to focus on access and opt-out rights with respect to that technology. And they're referenced, the new discussion draft regulations sometimes reference these other regulations that we haven't seen yet. But essentially, where we are right now is the California Privacy Protection Agency issued these like pre-rulemaking drafts of the cybersecurity audit and privacy risk assessment regulations. They're two separate documents. They're both very rough in some places. They look like regulations, but they've got a lot of underlined sections. And any place that's underlined is flagged as an area for discussion. And this was released in advance of the September 8th board meeting. This is the board of the CPPA of the agency. And they actually they talked through some of these key points, essentially where they're trying to decide which option they want to go with. You know, how stringent do they want to make these requirements? Who should it apply to? What would these assessments look like in practice? And then what do you need to do practically? There's a lot of open questions. And they issued these in advance for some discussion. The board did meet on, I think it was the 8th, and talked through some of the items and basically signaled that they weren't going to vote on these regulations in current form to make them like a formal rulemaking process. So we're still in like a pre-rulemaking stage where they've been working on these things behind the scenes, but they haven't formally submitted them for approval. They haven't opened them up to public comment in the traditional sense of like an official rulemaking proceeding.
Interesting, Aaron. So let me just make sure I have this right. So a couple of years ago, we had the CCPA, which had its own set of regulations promulgated against it. Then there was the ballot initiative, then resulted in the CPRA, which also calls for a number of areas of potential regulation, some of which, as you said, have already been promulgated and have gone into effect. Some of them are forthcoming, and we haven't actually seen what those could look like. Today, there is kind of a set of, I guess maybe it's too much to say they're proposed regulations, but kind of some directional conversation about what the regulations could look like for privacy risk assessments. Is that kind of a fair summary?
That's right. And there's two sets. That's one of the sets, which we can talk about in more detail today. And there's also a set for the cybersecurity audit. And in terms of the level of detail, they're quite detailed. They're just not final, right? So they've included a lot of draft language on this threshold or this criteria to be considered. It's just not clear whether they're going to adopt them all or expand them further. They've just kind of thrown them up for discussion amongst themselves, and eventually it'll be open for comment.
Yeah, I mean, that's kind of interesting, right? Because the rulemaking usually follows a traditional process where there could be a notice of proposed rulemaking and different types of regulations are set out, and the public has a chance to comment, and then there could be some periods of revision. We saw that play out in California with the regulations that were first proposed and then eventually adopted under the CCPA and the CPRA. Here, it's a little bit of a different approach where they're actually producing almost a discussion draft where that is going to be, I don't know, debated, discussed, however it is you want to describe that at the CPPA board meeting, which then almost kind of signals to the outside community about where the conversation may go, which then will become part of the notice of proposed rulemaking. Is that the way that is going to lay out?
That's what it looks like. And at the meeting, they signaled that their next meeting is coming up in November. They signaled that it sounds like the plan or the hope is to have drafts that they've agreed upon, hopefully agreed upon, and that they can vote on at the next meeting, at which point the formal rulemaking process would kick off, and then they would open it up for public comment and further discussion. It's not clear if that'll happen. They're also supposedly planning to issue the automated decision-making regulations at that next meeting, but we just don't know if it's going to be, are they going to kick the can further, or is this going to be the next one where it actually starts the formal rulemaking? We don't quite know yet.
Got it. Okay, so then let's dive into kind of what these things are designed to do. So you mentioned, right, two large categories. One is being the privacy risk assessments and the other one being the cybersecurity risk assessments. We'll defer the cyber conversation maybe for a future day and focus today on those privacy risk assessments. What is the kind of a general scope of what a risk assessment is going to look like, and when could it be triggered?
Sure. So the risk assessment, they're pretty broad, and they seem, at least the way they're thinking about them now in these preliminary drafts, they seem like they'd be triggered in a lot of instances. Now, this is actually similar to the risk assessments that are required under some of the other state laws that are already in effect. So Virginia, for example, has a basic requirement to conduct a privacy risk assessment if you engage in certain types of processing activities. The California requirement, it seems to align with that, at least the way they're thinking about it. But of course, in California fashion, it just goes way beyond, right? It goes much more detailed and much more, broader scope. Colorado also has, under the Colorado Privacy Act, has a very similar requirement. The thresholds are slightly different under those two states, but Colorado, of course, has issued regulations, and those are very detailed. And you'll actually see that if you were to do a cross comparison, and we haven't gone super deep on this yet because these are so preliminary. And if you look closely at these regulations, you'll actually see that they draw heavily from the Colorado regulations relating to the Colorado Privacy Act, which relate to the similar requirement around privacy risk assessments. So essentially what these are is a requirement that when a business is going to engage in certain risky processing activities, they're required to first undertake a privacy risk assessment, which requires weighing various factors. Essentially, you're considering the benefits to the business, to consumers, to society writ large, against the risks to a consumer's privacy. That's the short version of it. And it's going to sound similar to anyone who's ever looked at like a DPIA or a data protection impact assessment under GDPR EU. It's a similar concept, and it's based off of that very much. But you would be required to do this in advance. You need to document it. And if the current formulation goes forward, you'd be required to submit some kind of abridged version of this to the CPPA. So to the agency, you'd be required to submit this, and along with a certification that you've done the full robust list of assessment considerations and had the relevant stakeholders within the company sign off on this. And there's a lot of discussion about what exactly it's going to entail and which specific elements need to be included in your risk assessment. But that's the long and short of it. And California goes further than some of the other states, and they actually have an express prohibition on engaging in any of these processing activities if it's determined that it would result in a risk that outweighs the benefits to consumers or the business. So there's actually, there's some skin in the game. If you undertake one of these and it comes out that it's too high risk, you're prohibited from doing it.
So what are the types of triggers where you would have to conduct a privacy risk assessment? You mentioned earlier, it's kind of one of those ones where it's kind of the different types of risky activities. Are we just talking about automated decision-making, AI, or are we talking about a much larger universe?
Much larger. So the way it's framed, the phrase is processing activities that present significant risk to consumers' privacy. Some of these, they gave a list of examples of things that would be considered to fall within the significant risk category. Those include selling or sharing personal information. Now that's much broader, as you know. So that's going to be any business that's using third-party advertising on its website would be required under these to undertake a formal risk assessment. That's actually true in some of the other states as well, although we haven't seen as much attention around these requirements. But I think when it comes to be under California, it will see a lot more attention. So selling or sharing, PI, processing sensitive personal information with a carve-out. They're currently considering a carve-out for processing sensitive personal information of employees or independent contractors in basically in like the HR context. So if you're doing it for, benefits management, that would fall out. You wouldn't have to do it there. And then they flagged a lot of items for discussion. Those first two were not flagged for discussion. So I think we can feel fairly confident that they'll probably make it in there unless something big changes. So a third area, and this one's still up for discussion as to the exact scope of it, is automated decision-making. And in the current draft, they're looking at decisions that result in provision or denial of financial or lending services, housing, insurance, those types of decisions. So there's some focus on sensitivity. It's just not exactly clear how it will be framed in the end. Another area that would require conducting a risk assessment is processing the personal information of consumers under 16. So kids data, but defined at 16 rather than 13. Another is for monitoring of employees, contractors, job applicants, and students. That's an interesting one, using like technological monitoring processes. They've left some ambiguity as to exactly what that means, but they did flag some areas like keystroke loggers, productivity or attention monitors, video or audio recording, facial recognition, that type of thing. So used against those classes of consumers would trigger this. Also, Another area that would require this is monitoring public spaces. So processing personal information of consumers in publicly accessible places using technology. So things like monitoring behavior, location, movements. They listed a few examples being Wi-Fi or Bluetooth tracking, radio frequency identification, drones, facial recognition again in the public space. Geofencing is another one, location tracking, license plate recognition. And all of these are up for discussion still. So that when they put these in the draft regulations, they underline these areas as areas that they wanted to discuss further amongst the board. So we don't quite know the parameters of where these will land, but they're definitely signaling an interest in a lot of hot button issues. One last issue that they have flagged is for training of AI and automated decision-making technology models. So processing personal information to train AI or automated decision-making tools would also be an area that triggers the requirement to conduct a risk assessment.
It's almost like, Aaron, they took a list, as you said, right, the hot button issues. They take the list of all of the topics that were covered at the last, IAPP meeting and included that as all of the things that could trigger a DPIA or a privacy risk assessment, the way they're calling it in California. But what is unique and new here is that we have to potentially provide this proactively to the regulator in California for them to presumably review, provide scrutiny, and perhaps even second guess.
That's right. And it's something that you'd be required to produce the full report on request, from the AG or from the CPPA. So it's something you're supposed to have documented and maintained. So if there's ever an issue around this and the agency or the AG comes knocking, they can request to see the whole thing. So you have to be comfortable about what you're putting in there is accurate, because it could come to light someday. But also, like you said, what makes this even just a bigger change from how things have been done in the past is that, you're required to affirmatively, proactively go out and disclose at least some high-level version of this. And I know one of the things that came up at the board meeting, it was interesting, was there was a public comment, I believe it was somebody from Epic was there, and they were really stressing they wanted more transparency around this. So that I think there's going to be a push, I think, from certain advocates to try to have businesses publicly disclosing this, or maybe for the agency to even post these online. Not clear that any of that's going to happen, but it's interesting. There's certainly some interest there from some parties. So a lot to take in when you look at this as just kind of a suite of new requirements that aren't currently in place in this way, at least.
So did the proposed discussion draft of these regulations describe what this assessment needs to look like? And if so, can you just give us a flavor of what would need to be included within one of these privacy risk assessments?
Yeah, there's a lot. It's different. If you've ever seen a European style DPIA, those are very detailed in a specific sense. They focus a lot on like lawful basis and lawful grounds and all those types of things. Here in California fashions, it's very prescriptive. There's a very detailed list of things that they're at least now discussing to include in the list of minimum requirements. So I'll just run through. I don't know if we want to cover all these because there's a lot, but we'll cover at least some of the big ones. You're supposed to include a short summary of the processing that presents the significant risk, basically like describing how the business is collecting the information, using it, disclosing it, storing it, all the privacy notice type disclosures. You'd be expected to include that around the specific activity, the categories of information and whether any of them are sensitive under California law, description of the context of the activity, including the relationship between the business and the consumer. So, whether you have a first party relationship with them or something, if it's more attenuated, you'd probably be expected to describe that. This is an interesting one, a description of the consumer's reasonable expectations concerning the purpose for processing their information. So you're expected to read the minds of your consumers, which kind of makes sense, but could be challenging in some cases. It's your statement of what their reasonable expectations are, as well as the proposed purposes, compatibility within the context for which you collected the information. So all this gets pretty technical, but then you're also expected to give a list of the operational elements of the processing. So the planned method for collecting, using, disclosing the information, including the sources of the information, how this complies with California's data minimization requirements, including why you need to process this specific information, the relevance of the information to this, business purpose that you're undertaking. Also, how long are you going to retain that? So you need to basically factor in all these different pieces of your privacy compliance program and put them into your report. So like you might be pulling from your data retention policy. You need to apparently approximate the number of consumers whose information the business plans to process, which in some cases might not be that easy. Describe the technology used in the processing. Here's one that could be challenging if this makes it in. You're apparently required to name all of the service providers, contractors, or third parties to whom the business discloses or makes available for PI and the purpose. So this goes a little bit further than some of the requirements that are currently in the California privacy notice requirements or the notice of collection requirements. They do currently have like a little carve out that says if you're not able to name each party, identify them by category, it's just not clear if they're going to keep all these carve outs in or what level of detail they're going to go for. You need to have a detailed list of the purposes for processing the consumer's information in this context. And they really emphasize specificity. You can't just say things like to improve our services or for security purposes, which is a bit of a difference from the way we tend to draft privacy notices. You need to then, and I think this is really the core of the assessment, you need to walk through the benefits from the business perspective resulting from this processing, to the business, to the consumer, other stakeholders, and the public. They actually set out a pretty detailed formulation, but the key is that they're focused on things like the magnitude of the beneficial impacts and the likelihood that they occur. So you can't just, imagine some potential benefits in the future, that they actually want you to try to pin it down. And then as a counterpoint, you need to factor in the negative impacts to the consumer's privacy. These include the sources of the negative impacts. You have to describe the magnitude of those impacts and the likelihood that they may occur. On this piece, this is really, I think, the core of what they're looking for. And so they've set out a long list of negative impacts the business must consider at a minimum. And when you start to see this, if these all make it in there, this is actually going to be a pretty detailed exercise. You would be required to consider constitutional harms, such as chilling or deterring free speech or expression, security impacts, discrimination harms, impairing consumers' control over their PI or personal information, coercing or compelling consumers into allowing the processing of their personal information, exploiting consumers' vulnerabilities, such as age, employment, or student status, economic harms, and they've gone into quite a bit of detail there, potential physical harms to consumers or property, including processing that creates the opportunity for physical or sexual violence. So you can see they're really thinking broadly about these harms. Also reputational harms, including stigmatization. Some examples given were information shared related to like dating apps or implying someone who committed a crime. And then also psychological harms, such as emotional distress, stress, anxiety, embarrassment, fear. So you can see these are very broad reaching. There's a lot. I've never looked at most of these specific questions when doing a risk assessment, but California would like us to.
Yeah, I mean, Aaron, if I'm just hearing this for the first time, my immediate reaction is say, oh boy, right? There is a lot there. And I would, for a larger organization, I would need to hire a team of privacy professionals to be able to even identify what we think is in scope for these risk assessments, how many risk assessments I would need to do, and then to answer and consider thoughtfully all of those issues that you raised. That is a significant undertaking. And if I were somebody who is looking at the regulations in comparison to the statute, I'd say, are all of those things contemplated in the statute? Or is this an example of where there's being a lot more detail being added to the existing law?
I think that's exactly right. I think some of these issues aren't privacy issues per se. I mean, they're related, but it's an interesting example. What I think we don't know at this phase is whether this is a wish list, if this is just the list of everything they think is interesting to consider, and maybe not all this makes it in there. This might get culled down quite a bit. A lot of these items were listed in underlined, so clearly still for discussion, not final at all. I think we'll probably see some of these come out, but it's hard to say what, or it's possible they add more, depending who they're talking to, depending what kind of feedback they get from the public comment phase once they get there. I do think you're going to see an understandable pushback from the business community on some of these, just because the scope of undertaking this would be intense and the cost associated. I know one of the points that was mentioned several times at the meeting was the need for an economic impact analysis of this. They really do want to understand. So it was good to hear that it's not just pure pie in the sky, like, hey, let's make the best policy decision we can. They want to understand what is the practical impact here on business. Is this feasible? Is this something we can do and should do? So I think we'll see some shift, some focus come into the list, but this is at least the types of issues that they're looking at now.
Yeah, Aaron, we're going to have to become a regular of the show just to continue to keep us updated on how this develops, because it seems as though there are many paths that this can eventually take. And so in some ways, having this level of pre-proposed rulemaking, transparency, and areas of disclosure for discussion so that the community can understand where the regulators may take this proposed set of regulations is super helpful, even if it's maybe terrifying in the short term. So Aaron, I think as we wrap this episode up, oftentimes I'll ask guests to maybe play a quick role-playing exercise with me. And so maybe we can do that here. Let's suppose for a moment that you are an in-house counsel, leading the privacy team at a large organization with significant operations in California. And the senior executive hears a podcast like this one about all of the proposed regulations and what that may mean for the business. And they turn to you, Aaron, and they say, hey, Aaron, what should I do about this? Why don't you kind of give your perspective about, how you would be able to advise your business colleagues about what's happening?
Sure. Yeah. And I think there's a lot to consider. I think first and foremost, it's important to recognize that this isn't just a paper exercise. Really what they're pointing at here is they want to see that you have a robust privacy compliance program in place. If you look at all the different requirements, that's really what's feeding into this. They want to see that you've thought about the various issues, the various impacts. You have visibility throughout your organization. So I think step one would be, I'd want to feel confident that my organization has the privacy compliance program in place, that it needs to comply with the CCPA generally, as well as other privacy laws, because that's the type of visibility you're going to need to populate this type of thing. I don't think I would run out and start drafting up the template privacy risk assessment yet, just because this could change. This could get heavily streamlined, or they could add a whole new set of requirements that aren't currently contemplated. It's California, so anything goes. But I would keep this in mind, that this is one potential path, and we see that this is coming. This will be required. And to some extent, it already is required at a lower level in other jurisdictions. So I would be thinking about, what are the deficiencies with my current risk assessment process, assuming you have one. If you don't have one, I'd be thinking about, all right, well, we really need to be thinking about standing up a risk assessment process. And also, this isn't just a one-time exercise. This is something that's going to need to be reviewed and updated. There's actually some provisions in here about what that's going to look like. They're not final, but it talks about either keeping it accurate, which would mean just kind of reviewing and updating when there's a material change, or potentially redoing the entire thing or making updates at a periodic basis. So maybe every 1 year, every 2 years. Those are some of the figures they're considering. So you need to have a process in place in order to conduct these. You need to have a view into your full operations. So do those data mapping exercises. Make sure you understand what you have. Make sure you understand, where the data flows are happening, and start thinking about the risks. If you're aware of things that potentially have privacy risks that maybe haven't been mitigated fully, you're going to be required to describe them in writing very soon, in probably more detail than you've ever had to in the past. And it's going to be an interesting ride. But yeah, that's how I'd be thinking about your organization's compliance program.
Super helpful perspective on kind of those important impacts and where to take forward. And maybe if I would add one more, is be prepared and ready to comment when there is an opportunity to do that, because this is an area that, while all of these things sound great on paper, of all of the many things you want organizations to do and consider, just know that all of those things are significant undertakings that will have a significant economic impact on California businesses and businesses operating in the United States, frankly. And as a result, while some of the issues here are important to work through, I think the real importance is to make sure that we are balancing the business need with the regulatory and public need for these types of controls to put into place, and come up with ways that allow for transparency, allow for that careful rigor and thought, but without necessarily creating this bureaucratic infrastructure of having so much paper and so much internal documentation that the value is lost just in volume.
Completely agree. I think this is going to be a great opportunity for policy initiatives, get out there and comment, participate in this process. I know we've done that in the past for some of the previous rulemakings, and in some cases we're able to make some changes that really made them workable in ways where they weren't previously. So there's definitely an opportunity to engage there, or there will be once they finalize these and get to that formal rulemaking, which may be November, coming up soon though.
Yeah. And maybe one other thing that I would add, Aaron, is I started the show kind of talking about this in the frame of AI and automated decision making. And I think you rightfully pointed out, like those are important components of this, but it's actually much broader. But as we think about what's happening within this particular space, we are likely to start seeing more and more requirements to do these impact assessments with all different types of technology that have those automated and AI components. And so as that development happens within the EU and kind of is then embraced within the United States, I think more and more of that internal documentation, internal kind of thought rigor is going to be the norm as opposed to the exception.
Yep, I think that's exactly right. I think it's going to be very similar to some of the things we're seeing in other jurisdictions and other sectors. Another one is the age-appropriate design code. You're going to see some overlap with these other types of assessment requirements happening in these different spaces. But yeah, AI and automated decision-making are absolutely going to be implicated here. And businesses are going to need to be thinking about these processes. It's a new way of life. This is what the future is starting to shape up to look like.
Well, Aaron, really appreciate your expertise and your thoughtful approach to these issues. Thanks so much for joining the podcast.
Thanks for having me.
So with that, I'm Scott Loughlin. This is the Data Chronicles, and those are your data points.